Everyone. It is wonderful to have you all here. I'm Dan Tokaji. I'm the Dean of the University of Wisconsin Law School. And on behalf of our distinguished Fairchild Lecture Committee, on behalf of all the faculty and staff of the law school, it is my great honor to welcome you to the 2025 Thomas E. Fairchild Lecture. As some of you know well, this lecture series was established now 37 years ago, back in 1988, as a tribute to Judge Fairchild, initiated by his former clerks, some of whom are here today. The purpose is to bring a distinguished member of the legal profession from the bench bar academia to the law school to speak on something that's of importance to our profession, and what you'll be hearing today is very much that. The University of Wisconsin Law School had and still does have, much to our pride, a deep connection with Judge Fairchild throughout his life and beyond. He was a 1937 grad of the school, served as Wisconsin Attorney General, U.S. Attorney for the Western District of Wisconsin, a justice on the Wisconsin Supreme Court, and ultimately Chief Judge on the U.S. Court of Appeals for the Seventh Circuit until his death in 2007. And for those who had the privilege to know and work closely with the judge, well, they knew that he was justifiably renowned for his scholarly knowledge and for his remarkable sensitivity to the human condition that informed his lifelong search for equal justice under law. His legacy is part of what has brought such a distinguished group of former Fairchild lecturers here to our law school. And we are very pleased to have someone who is a very worthy member of this distinguished group in today's keynote speaker, the Honorable Robert Dow. Judge Dow served as a judge on the U.S. District Court for the Northern District of Illinois from 2007 till 2022. In December of that year, he became counselor to Chief Justice John Roberts at the United States Supreme Court, a really fascinating role that I'm sure brought many of you here today to learn more. In this capacity, he serves as the court's chief operating officer and assists the Chief Justice in his administrative responsibilities as head of the federal judiciary. Now, Judge Dow is an amazing man who's had a wonderful career in the law. So I won't be able to list all of the highlights in that storied career. I will say he served on the Judicial Conference's Advisory Committee on Civil Rules, chaired the Committee on Rule 23, MDL Subcommittee, blah, blah, blah. All that. Really fantastic stuff. He gave me permission, in fact, encouraged me to skip over all the amazing things, including being a Rhodes Scholar that he's done over the course of his career. But of course, to those of us here at UW-Madison, the most important thing is that he is a native Wisconsinite, having been born in Madison, Wisconsin, and having spent his formative years. First 2 years are always the most important right here. So welcome to you, Judge Dow. I also want to give a shout out to at least some of the distinguished members that we have here in our audience today. Justice Ann Walsh-Bradley, a member of our Board of Visitors, always a pleasure to see you, along with Judge Barbara Crabb, same. We're really privileged to have you both here. We have Michelle Benke, the still president-elect, so I now refer to her as Madam President-elect of the ABA. She will become president in August of this year. And former Milwaukee Mayor Tom Barrett is with us. Tom, it's great to finally see you in person. I know. Great to have you here, as well as Judge Conley. Where did you go? Oh, there you are. There you are, Judge. Great to have you here as well. Thank you for being with us. And you're all very distinguished, so we're pleased to have you all here. Moderating Moderating today's program will be our own Professor Nina Versava. Her research focuses on procedure, courts, judicial administration, legal ethics, and jurisprudence. So when the question arose of who should be the interlocutor with Judge Dow, it was a really easy choice for us. She's a great scholar, her work having appeared in Harvard Law Review, University of Chicago Law Review, same thing as Judge Dow. I'm not going to bore you by going through the whole list because you didn't come here to hear me talk. The goal here is really to make you all in the audience feel like you're listening in on a conversation between two extremely smartful people. So, Nina, thank you so much for serving in that role. Thanks again to you, Judge Dow, for being with us today. We're very honored to have your presence. And with that, I will turn it over to you, Professor Versava, to start us off.
Thank you. So we have a series of questions to get through. We also tend to save some time at the end. We'll try our best for questions from the audience. So I wanted to start with some questions about your education and career path. First, you had the opportunity to pursue a career in diplomacy, yet you chose law. So what ultimately drew you to the legal profession? And do you see any overlap between law and diplomacy?
Great. Well, thank you for the question. It's delightful to be here. I am a native Cheddarhead, although I only had the 2 years here, but I'm so pleased to be here. I've learned a lot about Judge Fairchild. I recommend to you Colin Fitzpatrick, who was our circuit executive for 40 years, did an oral history of the Seventh Circuit. And I hope you all will Google, since you're all great at Google, especially you students, Google oral history and Tom Fairchild. Just put that in. And what you're going to get is a series of interviews that Collins did with Judge Fairchild back in the 1990s that tell his entire life story. And it's fascinating and wonderful. And I really encourage you to do that. I clerked for Judge Flom, and many of you know Judge Flom. And I think the Fairchild clerks talk about Judge Fairchild the way Flom clerks talk about Judge Flom. And I think Judge Fairchild is someone you all should learn a lot about. And when you read this oral history, you will learn a lot about it because Collins knew how to do those. So I really recommend that to you. But I'm going to go back to diplomacy now. So one of the things that the dean skipped over about my background is that I actually have a doctorate in international relations. And I was a graduate student in international relations. And I still think today that diplomacy is intrinsically more interesting than law. But here's what happened to me. I had the greatest internship in the world at the State Department when I was a grad student at Oxford. And I was put in the European and Canadian division, which is the only place where you could get by with only knowing English. Unfortunately, my Spanish is and I don't know any other languages, but it was a great placement. I was in the Arms Control Division of the European Bureau in the late 80s, which was a great time to be there. And I loved the job. The Foreign Service officers who were my supervisors were incredibly generous people. They'd all had really interesting careers. And at the end of the summer, I realized I wasn't going to be able to move every 3 years. And my then girlfriend, now wife, wasn't going to go for that either. And it was a bit of a disappointment to me because I really thought diplomacy is an amazing way to do public service. But I realized that wasn't going to be the way that I was able to do it. Now, we have a long, distinguished tradition in our country. And if you're looking for something else to read The Wise Men. It's a book about Dean Acheson and George Kennan and John McCloy. It's the post-World War II. And these are people who are lawyers and diplomats. And so that's sort of where I left it at that time, thinking I had no idea. You have no idea when you're 23 years old, which is where your career is going to take you. And for the rest of my career, I didn't do anything with diplomacy. And I had never heard of the job I have now, which is Counsel to the Chief Justice. I didn't know there was such a job when they called me to ask me if I'd be interested in doing it. I still didn't know what it was. But what's nice about that job is it does have some diplomacy because the Chief Justice and his colleagues have international exchanges with the Canadians, the European Court of Justice, and the UK High Court. And those are wonderful opportunities. And also the Chief Justice receives visitors from around the world, ambassadors and other chief justices. And we do also in our branch a lot of good rule of law work with developing democracies, mostly through the USAID. I will say no more about that today, but you know where my feelings lie. But I will also say about diplomacy, and then I'm going to pay tribute to Ambassador Barrett here. You all know him as Mayor Barrett, but I know him as Ambassador Barrett because last September, one of our exchanges is with the European Court of Justice, and this is where law and diplomacy really come together. And then I'll finish up how judges are diplomats too. But so we had the privilege of staying at the ambassador's residence in Luxembourg, and Tom and Chris Barrett were the greatest hosts that you could ever have for this. It was Chief Justice Roberts, Justice Kagan, Justice Breyer, and myself. If you could find 3 better traveling companions than those 3 justices, you should definitely go because they're wonderful people to travel with. And you know, our job was really a diplomatic job. We were meeting with the European Court of Justice. And in those 3 days, we had amazing exchanges. And what I realized is, again, the power of diplomacy and the power of people meeting with other people to talk about common problems and common goals, because we have so much in common with the European Court of Justice and with the Canadian Supreme Court and the High Court. I also realized that Ambassador Barrett is a revered person in Luxembourg, because we ended up, through his good offices, meeting with the Parliament, with all the justices in the European Court of Justice, with the Prime Minister. We had dinner with the Prime Minister. And what you can see from that is how much we have in common with all the other advanced liberal democracies who believe in the rule of law, how important the rule of law is, and how important it is to have that reinforced. It was an amazing experience for me. Now, what I realized about the European Court of Justice is 2 things that are different than our system. One is all their opinions are unanimous. And so as some of the people from our court who were there observed, they're both judges and diplomats, because at the end of the day, consensus between 27 countries, it's somewhat like trying to find consensus among 50 states. Some are rich, some are poor, some are conservative, some are liberal, and you have to try to find consensus. I thought that was an amazing lesson for all of us, because sometimes when we sit in panels, things are too divisive, and we sometimes forget that we are all in this together, and we are one government, and we're one country. We are separate branches, and the independence of the branches is very important. I commend to you the Chief Justice's year-end report. If you haven't read it, please do. It's about judicial independence. Judicial independence is a really important topic. I will shout out the ABA right now for standing up for us last Tuesday. But I hope that you all will read that, as law students in particular, because the traditions in our country are so important. And without getting political at all, I would encourage you to read the Chief's year-end report and think about how important judicial independence is. And I know Judge Crabb, I'm sure, and Judge Conley will agree with what I'm going to say here as Article 3 judges. Judicial independence is really a byproduct of lifetime tenure and salary protection in our Constitution. And I felt every day as a judge that I could make the decision I thought was right, because there are no threats to me. I mean, people talk about impeachment. If you go to your Twitter feed, you'll see threats to impeach judges. There have been 5 judges impeached in 225 years. It's not going to happen. And that's a beautiful thing for us to do what we think is right in every single case. And I feel like for 17 years, I've had the ability to do that. And it's because of the way our Constitution is set up. So I hope you guys will read that. It's well worth it. But let me go back to diplomacy now. So one of the great accomplishments, I think, and this is what Ambassador Barrett was doing, was advancing the rule of law with soft power. And soft power is so hard to come by. And we have it. We have soft power. And this is what I learned about diplomacy and judging, is that judges have soft power too. And it's an amazing thing that you learn with the job, is how much soft power you have, particularly as a district judge. And here's how you get the soft power. You get the soft power by treating every single person who comes into your courtroom with respect and dignity. Because at the end of the day, If they go to litigation, half of them are going to lose. That's the way it goes in our trial system. Our trial system is basically all or nothing for the most part. Now, most of our cases do not resolve by trial. They resolve before trial. And this is where judges, and district judges and magistrate judges in particular, have a lot of soft power. If the lawyers who come into your courtroom feel heard, they will help you get to the right result. If the parties who come to your courtroom feel heard and respected, they will work with you to try to get the right result in every case. And the soft power of the judge is to guide people. I always felt the longer I was a judge, the better I was at exercising that soft power. And that soft power is to get two people who don't see anything together to go out in the room and figure it out. When lawyers come unprepared and you ask them a question and they don't have the answer, if you send them to the jury room, they're going to figure it out in 30 minutes because they don't want to come back and tell you they can't figure it out. That's the soft power of judges. The other soft power of judges is when you bring someone in for a settlement conference. And I had one time where a litigant yelled at me. She had a lawyer, but she yelled at me in the settlement conference. And my clerk wanted to intervene and defend me. And I just went like that, and she sat down. And then afterwards, she said to me, "Why did you let her yell at you?" And I said, "She just had her day in court, and that's all she wanted." And I was able to then say to her lawyer, "If she does that in front of the jury, you know she's getting zero. You know that, right?" And he said, "Of course I know that, but you need to talk to her." So then after she yelled at me, I was able to talk to her. And what I basically said to her is, "I've seen this movie before. I'm sure you guys have seen this movie before. Justice, I'm sure you've seen this movie before too." And what I was able to say is, like, this is what I think is going to happen in this case. And after I do that, I'm going to now go over and talk to defense lawyers, and I'm going to try to get them to give you every dollar that they have in that they've set aside for this case for you. And then you get to decide whether you want to take that money or go to trial. That's the soft power that judges have. And as a district judge, you have immense soft power. And I think it's something that it's a reason I love being a district judge, is you have all that soft power and you can use it for good. And you can use it. I mean, when I was a rookie judge, I knew nothing. I was an appellate lawyer at Mayor Brown. I had no idea how to be a judge. The first time I saw a trial, I was the judge. I do not recommend that. That's a really hard year. You have to learn the job on the fly. But once you figure out the job, there's so much good you can do with it. And, you know, the last couple of sentencings I did, after the sentencing, I would go down and I'd talk to the defendant's mom. When I was a baby judge, I would never have had the guts to do that. But what the message I was trying to send was like, we're all in this together. And your son's going to be released from prison in whatever it was, 3 years. And he's going to be on supervised release for a couple of years. And in that time, I want you to understand that we have resources. And we have mental health treatment, we have drug treatment, we have job training, all these things. But we can't make your son do this. Maybe you can, but we can't. But we're all in this together. That's the soft power of a district judge. And it's very much like the soft power of a diplomat. I know I went on way too long, but I wanted to say what a great role model Ambassador Barrett was for that. And I could see how much he was loved in Luxembourg. So if you ever go back, I bet you're never gonna have to buy a beer.
That was wonderful, thank you. So we heard a bit about how you made your career choices. Many law students struggle with whether to pursue a career in public service or private practice, and if in public service, what kind of public service, what kind of private practice. So what advice would you give to students who are uncertain about their career direction?
Okay, there's a lot of ways I can take this on. Let me start with this. When I became a lawyer, it wasn't that uncommon to only have one job after law school. You would go to a law firm, you would do good work for 7 years, they'd make you a partner and you'd spend your whole career there. There may be even some people in this room who've done that. It's almost unheard of today. So the first job you take will almost certainly not be the last job, and it might not even be close to the last job. So go take a risk. Take a job that looks fun and interesting. It's not going to be your last job, almost certainly. And there's a lot of serendipity. I met with a bunch of the students earlier today, and I talked about the serendipity of how jobs either come to you or don't come to you. And the job you think you never had a chance at, you end up getting. The job you thought you surely were going to get someday, you never got. And that's happened to me on both ways. Sometimes I got lucky and the stars lined in my favor, and sometimes I didn't. But so don't be afraid to take a risk. Try something new. It's okay. There are no irremediable mistakes you're going to make with a law degree from the University of Wisconsin. You're all going to be fine. And you're all going to have 10 or 20 or, you're going to have more than one job in your career. So that's one thing. The answer to the question between private sector and public service and academia is do them all. Do them all. You will be really fortunate in your career if you have an opportunity to do all of those things. I feel extremely blessed in my career to have had 12 and a half years in the private sector. It was a wonderful job. I could have stayed at Mayor Brown the rest of my life. I love the work. I love the people. The problems were important. When you're a lawyer, you have a credential that so few people have, and you can use that credential for the good of everybody. And I sort of laugh about, like I became mostly a constitutional and appellate lawyer at Mayor Brown. And I always used to say, if you have a First Amendment problem, call me. And if you have a different legal problem, call my dad. My dad wasn't a lawyer, but my dad knew he was a business person. He had his own small business, and he knew more about that kind of law than I did, even though I was a lawyer. But if you're a lawyer, you still know more than your clients do. And I have all these people in my district. If you are a member of our trial bar, you have to agree to accept pro bono appointments. And I have lawyers coming in saying, I don't think I can take this pro bono appointment because it's a civil rights case and I'm not a civil rights lawyer. And what I say to them is, do you think you know more about civil rights law than the pro se litigant who wants your help? And the answer is, of course you do. So when you're a lawyer, don't be afraid to go out somewhere. You know most of what you need to know about any area of law because you have a law degree, and you know how to figure it out if you don't know it. So don't be afraid. If you think you're a private sector lawyer, you can also be a public interest lawyer at the same time. Take a pro bono case. The pro bono cases were incredible opportunities for me. I was a second-year lawyer, and I was arguing in the Illinois Supreme Court. None of our clients were going to pay for me to do that, but I had a pro bono case where they granted the PLA. All right, there I was in the Illinois Supreme Court. So you'll find opportunities that way, but do it all. And don't let anybody tell you you shouldn't go into the private sector. It's fine to go into the private sector. Don't let anybody tell you you shouldn't make money. It's fine to make money. But if you get an opportunity to do public service, you won't regret it. And if you get an opportunity to teach, I don't think you'll regret it either. I've loved doing all of those things. And and if I go back to the private sector, I hope nobody ever will hold that against me either. But, I think do them all. Do them all. And don't let anybody tell you you have to do one or the other.
Great advice. Let's go to some questions about clerking and judicial mentorship. So you clerked for Judge Joel Flom of the Seventh Circuit. What are the most valuable lessons you learned from him? And how did those lessons shape your own judicial philosophy?
Wow. So I would say for Judge Flom, he always said public service is the highest calling, and that never left me. It's funny because I had no thought of ever being a judge before I clerked for Judge Flom. Like, it never occurred to me that was on the menu. And after I clerked for Judge Flom, that's the only job I ever won. And so I think, but again, lightning has to strike you. And I'm sure all the judges in this room would agree with me that you can't, you gotta, but if you want to be a judge, it's a very honorable thing. And the other thing I said about Judge Flom, and I always said this to all of his other clerks, that I knew all of his clerks because they all worked in my building basically. And I said, watch everything he does. Like, you might think what you're going to learn is how to write opinions or how to do law, but watch everything he does. Because he treated Chief Judge Posner and the guy who emptied his garbage exactly the same way. And, that's the way you should be. And I think that's what I always said about him, is watch everything he does. And I would never have done anything, including take the crazy job I have now, without consulting with him. And I'm not quite sure what I'm going to do now. I'm going to have to consult the rest of you judges. But I think when you clerk, you have a mentor for life. And I know that all the judges here would agree with me that, we would drop anything for our clerks to help them. And believe me, in the last 4 weeks, I've had a lot of calls from clerks. I bet you guys have too. I have clerks who work at Maine Justice. I have clerks who work in U.S. attorneys' offices. I have clerks who work for alphabet agencies, and they're all calling me to say, what am I going to do now? But when you have that kind of relationship, you're always going to be a mentor to your clerks. And that's what Judge Flom was for me. And my chambers is organized exactly as Flom's is, because that's what I knew and it worked. And my bet is that all the people who have clerked for you, other judges in this room, they probably do the same thing. And I bet my clerks do too. It's a special relationship.
Like Judge Flom, Thomas Fairchild was a judge on the Seventh Circuit Court of Appeals. Could you share some reflections about him and his legacy?
Sure. So I met Judge Fairchild one time. So he was 82 years old when I met him, and he was a senior judge in the Seventh Circuit. And there was a panel that had Judge Fairchild on. At the same time, I met Judge Krapp because she was also on a panel of the Seventh Circuit that year. Then they threw out all the visiting judges, and they let us back about 20 years later. But what I remember of Judge Fairchild is he was very kind and took the time to actually get to know the Flom clerks, which not every judge did, but he did. I have another Judge Fairchild story. So when I was I had to be my 5th year as a judge, I took my robe home for the weekend because it needed to be dry cleaned. And I was supposed to pick it up the cleaners at 7 in the morning on Monday and get on the train to go into Chicago, because I always took the 7:37 train in. And I could just barely make it to my 9 o'clock call because I live in Joliet, which is 45 miles from Chicago. And I showed up at Chambers about 8:55 and realized I didn't have a robe. That's a problem for a judge. So fortunately, one of my clerks that year had clerked for Judge Evans. I know many of you here would have known and worked with Terry Evans. And Terry Evans was one of the nicest, sweetest people in the whole world. He'd been a district judge for a long time. He's a Court of Appeals judge. He and Judge Flom were really close friends. And Judge Evans got ill with a very rare disease and died pretty suddenly. And my clerk had just finished a clerkship for Judge Evans. So she said, I have the solution for you. There's a robe in Judge Evans's chambers. So she went and collected Judge Evans's robe for me. Now, Judge Evans was a lot shorter than I am. So I put this robe on and I realized it really wasn't meant for me because the arms are about to here. But I wore it till I retrieved my own robe and I forgot to return it. And the reason I know this is because I was in my chambers in Chicago, I would say about a year ago, desperately looking for a suit because I was supposed to give a talk in Chicago and the suit I was wearing had a mishap at lunch. And so I found a suit in my chambers that still fit me, but I also found this robe. And I was like, that's not my robe. And I looked in it and it came to me that had to be Terry Evans's robe. But then I looked at the lapel inside the little robe thing that you can hang on there. And there's actually a little label in there and it says Thomas Fairchild. So if any of you are Fairchild clerks, and I know some of you are, or if you're Fairchild family, I apologize. I'm holding an heirloom of yours. And if you would like it, I promise to repair the right sleeve, which did not suffer through my long arms. But I promise to repair it. And if the University of Wisconsin would like to take custody of this, I'm sure the Fairchild family would be okay with that too. But so I realize I have this heirloom of the Fairchild family, but I also commend to you the research I've done lately. So Judge Fairchild is kind of a throwback. And I was saying this earlier to the students I met with. So Judge Fairchild's path to the Seventh Circuit was not the normal path these days. He was the Attorney General of Wisconsin. I imagine from what I read, he probably could have been the Attorney General for a long time. But instead, they recruited him to run for the US Senate. And he lost 2 Senate races in a row. And the second Senate race, he ran against Joe McCarthy. And unfortunately for the country, Judge Fairchild did not win that race. So we had a couple more years of Joe McCarthy before he imploded. And you probably all will know the story of that. You Wisconsinites probably know that story much better than I could possibly tell it. After that, Judge Fairchild went on the Wisconsin Supreme Court, where his father had served, and his father had been the Chief Justice. And in the 60s, and you can read all about this in the oral history, in the 60s, there was a vacancy. There's only 2 Wisconsin seats in the Seventh Circuit. And there was a vacancy for one of them. And what he tells in the oral history is like, He said, basically, I don't think I would have had a chance at these seats except that I had been in politics. And so I knew the senators, and the senators knew that I would be a good Court of Appeals judge. And that's, the path to Court of Appeals and Supreme Court at that time was much more common to come from politics than it is today. I give a lot of tours at the Supreme Court. If you all show up in Washington, I'd be happy to give you a tour too. And I really owe you a tour, Tom. I owe you and Chris the greatest tour I could possibly give. But I hope you will come out. And when I give tours of the East Conference Room, or West Conference Room in particular, I point out all the justices, all the chief justices on the wall, and I say, do you know what this person did before they went on the bench? Do you know what this person did? And in the West Conference Room, we have Chief Justice White, who was appointed by, and I said, anybody know who appointed him? He was appointed in 1910. Can anybody tell me who appointed Edward Douglas White to be Chief Justice in 1910? Anybody? Nobody. Okay, so it was William Howard Taft. The next portrait in the room is William Howard Taft. Now, Taft was president, and the job he really wanted was Chief Justice. So he appointed a 65-year-old guy to be Chief Justice when the life expectancy was 65, because he was hoping the job would come open. It did come open for him. So the next portrait in the room is Taft. Then I go across the room and I say, that's Charles Evans Hughes. Charles Evans Hughes, he was on the court from 1911 to 1916. Do you know why he quit? He quit to be the Republican candidate for president. And if the electoral votes of California were switched, he would have been the 28th president. So he lost. He was appointed Chief Justice when Taft died. Then I go to the other side of the room. I look at Fred Vinson, who was the Chief Justice. Does anybody know what Fred Vinson's job was before he was Chief Justice? He was Secretary of the Treasury. Then I go to the next Chief Justice. That was Earl Warren. Anybody know what Earl Warren's job was before he was Chief Justice? And I say, he was the governor of California. I say, does anybody know what judicial positions Earl Warren held before he was Chief Justice of the United States? The answer is none. He had not been a judge, and then he was Chief Justice of the United States. That was a pretty common path in that time, and that was Judge Fairchild's path. Today, we have 9 Supreme Court justices. We have 8 Court of Appeals judges, and the only one who wasn't a Court of Appeals judge was Solicitor General. We got a bunch of appellate lawyers. We have no political people on the court at all. I don't know that any of them has ever held office. I mean, Sandra Day O'Connor, I think, was the last justice who held political office, as far as I can tell. It was a different time. And that's why I think for you students, it would be really educational for you to read the oral history of how Judge Fairchild got to the Court of Appeals. It's really interesting, and it's different than what you see today.
Thanks for that. I think we could benefit from hearing about your experience in appellate practice and the advice that you'd give based on it. So before becoming a judge, you practiced appellate litigation at Mayer Brown. What distinguishes great appellate brief writing from merely competent writing? And in your experience, what are the most common mistakes that lawyers make when they write briefs?
Well, I think everybody will give you a different story on what makes great writing. I will say when I was at Mayer Brown, how I learned to write better was every single edit that a senior person put on my briefs, my drafts, I looked at. I wanted to try to figure out why they did what they did. So pay very careful attention to the edits, because there's a reason. There's a reason why they did what they did. And if you don't know, you should ask. I think that you don't want to be too clever in writing, because there's a formality that goes with appearing in court, the same formality why we wear robes and why we wear a suit under our robe. And there's a majesty that comes with walking in a courtroom that I still think everybody should feel. And I'm an incredibly informal person. And I tell everybody, when you're not on the bench, you got to call me Bob. It's a weird enough job if you're going to call me judge when I'm coaching a basketball game. I played in a basketball game with the DC Circuit Clerks last year, and some kid decked me with a pick. He picked me up and he said, "Sorry, Judge." I'm like, no, nobody calls me Judge. But there's a formality to the courtroom, and there's a formality to legal writing. But within that, you want to have informal formality. I think that's the way I would put it. Make it a little bit interesting. Not too interesting, but a little bit interesting. I use a lot of ands and buts to begin sentences. I'm sure my high school teachers would frown on that, but I think it's actually makes your brief much more conversational that way. Vary your sentence structure, but there's 1,000 ways to write. And the best way to learn to be a better writer is to do more of it. Do more of it. And then ask the senior people why they did what they did. As an appellate lawyer, I would say the biggest mistake people make, and there's an appellate judge in here, so maybe she'll correct me, but I would say too many issues and burying the lead. Those would be my two biggest criticism. That's equally true of district court writing. You just get more pages in the appellate court, but you're still trying to make the same point. And so if you have more than 3 arguments on appeal, you're telling the judge, I'm throwing everything at the wall and hoping something. Because there can't be that many reversible errors unless you had the worst trial of all time or the worst summary judgment ruling of all time. It's also, don't bury the lead. If you have a 7th Circuit case on precedent and you're in Judge Crabb's courtroom or Judge Conley's or mine, that's a winner. That's a winner every day. And you don't need 10 pages to tell me that if the 7th Circuit case is on point, you're going to win. So, so I think get to the point too, particularly in district court. Court of Appeals, they give you more time. Supreme Court, they even give you more time. But those would be my basic pieces of advice. But you know, the way to get to be a better writer is to write more and to have experienced people look at your work and tell you how you're doing.
How do you approach writing opinions as a judge? And do you consciously consider how the appellate judges will perceive your opinions?
Well, as an appellate lawyer, the second question is yes, definitely. So my problem when I first started, I had many problems when I first started, but one of my problems, and my career clerk finally said this to me. She said, you know what your problem is, Judge? You want Court of Appeals work at district court prices. And that was true because I was still trying to write Mayor Brown briefs into my district court opinions. And you don't have time to do that. We have too many cases. The first time I had a preliminary injunction, I decided I was going to write it myself. And it turned out I was like Sisyphus pushing the ball up the hill. And it took me 4 months to write a preliminary injunction opinion. If you read Rule 65, that's a no-no. You're supposed to do these as quickly as you humanly can, and I wasn't. And the reason was I'd draft 15 pages and then I'd have to go to trial. And 2 weeks later, I'd pick the opinion up again and I'd have to start over. And so I made a rule after probably a year or 2 of that suffering. I made a rule and I said to my clerks, if it's more than 5 pages, you guys are doing the first draft. If it's 5 pages or less and I want to do it, I can do it. And I got really good at writing shorter opinions. And I always said to my clerks, and many of my clerks are way smarter than me. And I always said to my clerks, like, you guys are smarter than me, but I have more experience than you. And that's why I can write these opinions so fast. But after, you know, when you're a trial judge, and you got 300 civil cases in your docket, 50 criminal cases, you cannot write 40-page opinions on everything. When you're at Mayor Brown, you can write a 40-page brief on anything and your clients will pay for it because they're all bet the company cases and they want every single thing to be perfect. And that was such a luxury as a lawyer. And as a district judge, my career clerk finally beat it out of me that I couldn't do that. And it was good for me to learn to be quicker and learn that everything doesn't need that kind of a dissertation.
Mm-hmm. So I'm going to jump to some questions about judicial rules committees and reform to make sure we get to these out of self-interest because I'm especially interested in these topics. So you chaired the Judicial Conference Advisory Committee on Civil Rules, helping to shape how federal litigation works. Could you talk to us about how the committee decides which rules to amend and how the process looks?
So here's the beauty. Maybe this is a secret. Nobody knows this, but anybody can propose an amendment to the rules. And that was true for the appellate rules, the bankruptcy rules, the civil rules, the criminal rules, and the evidence rules. There's 5 rules committees. And most of our proposed amendments come from lawyers. Many of them come from bar groups. Many of them come from judges. Many of them come from the academy. And some of them come from pro se litigants. And some of them come from people who are just observers of the court. And every single person who writes in a suggestion to the Rules Committee lands on our agenda. Now, sometimes they get very quick consideration. Sometimes they get consideration that takes 8 years. So there's a proposed rule right now in multi-district litigation. That's just taken 8 years. But anybody can propose a rule, anybody, and we look at them all. Now, here's how the rules committees operate. 2 words, transparency and consensus. So every meeting of the rules committee and every meeting of our subcommittees, which is really the way we do the heavy lifting, there are minutes taken and they are recorded in agenda books. And twice a year, we have agenda books that are published by the Administrative Office of the U.S. Courts. And they are 500 pages, 800 pages. The 2 subcommittees I chaired were Rule 23, which gave you your 2018 amendments, and the MDL, which is going to give you Rule 16.1 that will go into effect in December of this year, unless Congress stops it, and it's very unlikely they're going to stop it. Those were a huge lift. Rule 23 took 5 years. The MDL rules taken 8 years. You can go through and look at the entire history of how those rules came about. And the original suggestions, most of which hit the cutting room floor, and the rule as it will be promulgated are very different. And that's because the process is really good. The subcommittee has to approve it, the full committee has to approve it, the standing committee has to approve it. When that happens, it's approved for publication. Then everybody in the planet has a chance to take a shot at that rule and decide whether they should make a comment on it. And for Rule 23, we've got hundreds of public comments. For the MDL rule, we may have gotten even more. We have some esoteric rules that were changed in my time in the Rules Committee, like 30B6. That's taking a deposition of a corporate representative. Who knew how interesting that was? But we got a lot of comments on that too. All those comments are taken into consideration by the subcommittee, the full committee, the standing committee. You got to run that gauntlet again, and then it's approved for adoption. After that, it has to get through the Judicial Conference of the United States and the Supreme Court and Congress. And after that, it's longer than the I'm just a bill thing that you all had. If you're my age and you listen to Schoolhouse Rock, if we did a Schoolhouse Rock for how a rule gets to be a rule, it would take days. But that's how it is. And I think it's a really good process. Here's the consensus piece of it. If the plaintiffs bar, the defense bar, the academy, or the judges, any one of those groups doesn't like the rule, it's at least going to get changed before it's adopted, and it might get stopped altogether. If any of those groups lays down on the railroad tracks, it's unlikely the train is going to come through. And there's probably, there may be some justifiable criticism of that, because there may be times where the rules need sort of shock therapy instead of a gradual tweak. But for the most part, I think that system has served us really well. I think the rules of civil procedure, I've felt as a district judge for 17 years that they have well served me. I think it's a good process, and it was really, really an honor to be part of that. And I miss it. I miss my rules committee geek friends. They were all good people to work with.
Great. I want to make sure we spend some time talking about your role as special counselor to the Chief Justice of the United States Supreme Court. So as counselor to Chief Justice John Roberts, you serve as a key advisor and administrator for the Supreme Court. So what does a typical day in that role look like?
So I should start by saying I didn't know this job existed until I got a call asking me if I was interested in it. And I said, what does that person do? And it turns out it is a really interesting job, but there's no typical day. So from September until the end of June, every day is crazy because the court's in session. And maybe it's just the environment we're in now, but it seems like everything is coming to the court. And the one thing I do not do is talk to the chief about the merits of cases. I've never talked to him about the merits of a case. He has no idea whether I agree or disagree with all of the decisions he's made since I got there. And it's good for both of us. My predecessor said, that's a rule we've had, and I think it serves us both well. But everything else that comes to the branch somehow ends up on my desk. And it's really interesting to do that. So inside the building, I'm chief of staff, essentially. There's 650 employees at the Supreme Court. A third of them are security. Basically, if it's going to get on the chief's desk, it has to go through me. And I think that's helpful for him to have a judge. I'm the first judge who's had this job, but it's helpful to look at it that way. And then the rest of it is the branch. So the branch is run by the Judicial Conference. There are 25 Judicial Conference committees. I help the chief figure out who should be on this committee. We have the international visitors, the diplomatic part of the job. That's awesome too. We love doing that. I think it always makes us both feel really good and that our court is well respected abroad. I mean, we have been at this longer than any other court, longer than any other. We have a constitution that's 235 years old. A lot of the foreign justices who come, we had justices who came and say, our constitution was adopted in 2014. And I know a lot about your constitution because our constitution was drafted by a University of Pennsylvania professor who modeled on your constitution. That feels pretty good to hear that, actually. And then relations with the other branches, that's a big part of my job too. It's interesting how much people think the Chief Justice has a lot more power than he actually has. He always says that Chief Justice Rehnquist told him, the job comes with reins, just don't pull them too hard because they're not attached to anything. And that's, I think every judge has their own commission. And people ask about the legitimacy of the court. Here's what makes you legitimate as a judge or a court, at least in Article 3. A president nominated you, the Senate confirmed you, and you have on your wall a commission. And the commission says you are authorized to exercise the judicial power of the United States. That's a pretty amazing thing. But every one of the 9 justices has the same commission that says exactly the same thing. And the idea that the Chief Justice can go down the hall and tell his colleagues, vote this way or recuse yourself from a case or this or that or the other thing. I mean, that doesn't happen anymore there than it happens in the Court of Appeals. Everybody has their own commission and they have their own obligation. They have their own responsibility to exercise their own independent judgment. That's what we all do as judges. So it's interesting that I asked my predecessor, what's the hardest part of the job? And he said, it's when the chief goes down. The chief tells you to tell his colleagues to do things they don't want to do. And that is true. That's a very hard part of the job, but they don't have to listen to me either.
So you mentioned legitimacy. There's legitimacy and there are perceptions of legitimacy. And in recent years, public confidence in the courts has maybe been questioned, or some people think that it's diminishing. Do you think that perceptions of legitimacy are a real concern? And from an administrative perspective, do you think that there's anything that can be done to strengthen public trust in the judiciary?
So I've always thought that we as judges speak through our opinions, and that's really the only way we speak. Now, this is an example of me speaking not through an opinion. And I think the justices and other judges, we're also under the canons of judicial ethics. We are encouraged to do education. And I think that's the thing that might help the best. So I was encouraged by the poll that came out from the law school down the street. That Marquette does these polling, and the Supreme Court has gotten back above 50%. That's not the way. That's not the reason we do what we do. A lot of people don't understand that. All of you law students have read Federalist 78, have you not? So we're supposed to be counter-majoritarian sometimes. A lot of what we're supposed to do is uphold the Constitution, and that's got to be a timeless exercise. It can't just be, we can't stick our finger up to the wind. Nevertheless, I am happy that people are approving of what we're doing, but we can't ever look at our jobs we're supposed to be the last people standing to do the unpopular thing. So I think about, let's pick an older case, West Virginia versus Barnett. I assume some of you have read that if you took First Amendment. So this is the case in 1940, there was a case called Gobitis, and Gobitis ruled against the Jehovah's Witnesses and said that they were supposed to stand and salute the flag. And West Virginia versus Barnett overruled that. And there's a great statement in there by Justice Jackson that says, if there's one fixed star in our constitutional constellation, it's that no government official, high or petty, can prescribe how you're supposed to think. And that is absolutely what we're supposed to be doing. And in 1943, if you took a poll, 90% of the people would have said, of course, everybody's supposed to salute the flag. We're in the middle of a war here. and the court stood up for the Jehovah's Witnesses. That's part of what we're supposed to do. So we can't want to be popular, but I think we would be more popular the more people understood what we actually do. The number one question I get from my friends is, how do I avoid jury duty? And I never answer that question honestly, because they shouldn't want to avoid jury duty. Everybody should want to serve on a jury. I would pay money to serve on a jury. After presiding over 100 jury trials, I would love to be a juror just once to have that experience. Now, when I tell people what I do, I will probably be stricken for cause or for peremptory or whatever, and I'll understand that. But I would love to be in a jury, because I know, and I look, Barbara's smiling right now because she knows too. We know who doesn't want to be in a jury. We know the people who don't want to be in a jury, but sometimes they're still in a jury. And I always talk to my jurors after the trial. It's one of the most fascinating parts about being a judge. And every one of them, to a person, after the end of a jury trial, even the ones who desperately did not want to be there, says, thank you very much. Thank you for running a good courtroom. Thank you for being a fair judge. Thank you for making everybody feel welcome. And thank you for this opportunity to do public service. Thank you for this opportunity to meet these 11 other people I never would have met. Thank you for the opportunity to do what I thought was fair and just and do something really important. So you should do that. You should go to a sentencing. If you go to a sentencing, go to a Court of Appeals argument, come to a Supreme Court argument. I guarantee you, you will leave impressed. You will leave impressed. And that's my mantra. My mantra is, it's an old commercial. I thought it was Magnavox or Panasonic, but it turns out to be something much more obscure than that. But the mantra of the commercial is, the closer you look, the better we sound. And I think that's true of the judiciary. And so much attention is heaped on a few people in the judiciary who do things they shouldn't do. We've had some notable cases of judicial misconduct. You can read about those in the paper. I'm not going to talk about them today, but it's out there. And there are a few decisions that are both consequential and unpopular that everybody focuses on. And everybody ignores the general work that all of us do in the judiciary. And I think by and large, we do really good work. And if you do all the things I just said, I think you will leave impressed with what we do.
So for law students in the audience who may be considering judicial clerkships or litigation careers, what do you wish that you had known at the start that you didn't, or that you found out later?
About judging or lawyering?
I guess about lawyering will probably be more immediately relevant for the students.
I think it's pretty much what I said. So you get all worked up about your first job, and you think it's your last job, and it's not. And everything seems, and this is true of all students. So you take the ACT and you take the LSAT, you do this and that and the other thing, and everybody gets worked up about everything. And in today's sort of social media world, it's easier to get worked up, and it's easier to look at everybody else's curated life and think that's not my life, and therefore I'm not going to have the dream job, or I'm not going to have the, $1 million salary, whatever it is you think. If you just relax and explore and not think that the first destination is the last destination, I think you'll have a much more satisfying life in the law. And you might find that thing that you didn't think you were going to like, you're really going to like. And for me, that was being a trial judge, because I didn't think I was really going to like being a trial judge. And I was an appellate lawyer at Mayor Brown. I was 42 years old. I thought, I'll do this for 3 years and then they'll put me in the Court of Appeals. That never happened. But it turns out being a trial judge was an awesome job. For all the reasons I said to you before, what I loved about being a trial judge was there was endless variety. It was never the same thing. Like at Mayor Brown, it was great too, but I will confess, I wrote the same brief for 6 months in the 11th Amendment. I wrote it for a bunch of different courts, but it got boring after a while. I've never had a boring day as a district judge. I hope the other district judges in the room will agree with me. It's so interesting, and it's so challenging, and it's so nice to deal with regular people all the time too. And that's something I underappreciated, because as an appellate lawyer at Mayor Brown, you don't deal with a lot of regular people unless you take a lot of pro bono cases, which I did. But it's the things you don't expect may be the thing that you end up doing for the rest of your life. So be open to it. As a judge, what do I wish I knew? I wish I knew how to try a case. The last day I left Mayor Brown, the head of the pro bono group gave me a Kennedy $50. It was attached to a piece of cardboard that said, "In case of emergency, flip me." I said, "What's this all about?" He said, "You know, they're going to ask you pretty soon, like people are going to look at you and they're going to say objection. And you're going to have to rule one way or the other." And he said, "There's only two right answers. You might not know this right now, but there's only two right answers: sustained or overruled. But you should use this in case you need it." Now, this is what I learned. And Judge Flom helped me with this. What I learned was you got to trust your instincts. That's another thing I would say to you lawyers, you young lawyers, students, trust your instincts. If it feels right about a job or somebody asks you to do something and it feels right, it's probably okay to do it. If it feels wrong, if you have a question about whether it's right or wrong, it may very well be wrong. So trust your instincts on it. And that's what I learned as a trial judge too, is trust your instincts. Like you can't have a sidebar every time someone says objection. I wasn't sure about that in my first couple of trials, but it turns out you can't do that. You have to trust your instincts. And that's how I became a better judge. Is I called Judge Flom and I said, "I am struggling with this job because I don't have confidence in what I'm doing because I've never done this before." And this is what he said, and I hope you guys will take this to heart. He said, "Dow, you're making this job way too hard." He said, 98% of what you do as a district judge is completely unreviewable. And he said, if they ask for extension time and the lawyer wants the time, wants 3 weeks, and the other side says, give them 2. If you give them 1, 2, 3, or 4, no one can appeal that. Then he said, 98% of what you is reviewable is reviewed for abuse of discretion. So as long as you know the car was red and the light was green, not the other way around, you're going to be fine. So a couple times a year in this job, you have to make a hard decision. That's why they pay money for this job. And he'd been a trial judge for 10 years. And he said, but those are almost always questions of law. That's what you've done for your whole life. You're really good at that. So go do your job. Once you internalize that as a district judge, and if you've been a trial lawyer, you can probably internalize it on day one, but if you haven't, it takes a while. Once you internalize it, it's the greatest job in the world for all the reasons I've said.
What do you think about taking a few questions from the audience before wrapping?
Fire away. Just don't ask me if there should be an enforceable code of ethics. I'll get in trouble if I answer that. Yeah.
Yeah, thanks. I was interested in reading this handout about this program that the Chief Justice plays a role as Chancellor of the Smithsonian. How did that evolve? And in your job, do you play any role with respect to the Smithsonian?
So the Smithsonian Institution was created in the 1840s. And the Chief Justice and the Vice President of the United States are both like written into the charter essentially as officers, like ex officio, whoever the occupant of the office is, they have a role at the Smithsonian. And it turns out that Chief Justices are much more reliable in their jobs than vice presidents because we had a constitutional amendment, and I don't know off the top of my head which one it was, but let's just go back to 1849 when Zachary Taylor was elected president. He died in office. Millard Fillmore became president. Do you know who the vice president was for the rest of Millard Fillmore's term as president? There wasn't one. And there wasn't one for every president who died in office. So it turns out at the Smithsonian, if they had made the vice president the chancellor, there would have been a vacancy for a lot of the time. The chief justices were always reliable to show up as chancellor. So that's how chief justices became the chancellor. And all the chief justices since Roger Taney have been chancellors of the Smithsonian. It's a really cool thing because the chief justice presides over the regents' meetings. And they don't ask him to run museums. The people who run the Smithsonian are amazing at running museums, but sometimes they have some legal issues that come up and they ask the lawyers in the room, which happen to be me and the chief, and they have a legal counsel. Like, what do you think about this? It's really fun. It's interesting. We're not running museums, but I think he thinks it's one of the great parts of his job, actually. And the Smithsonian is an amazing institution. It's the greatest collection of museums in the world. And you know what's really cool about it is they're all free. So if you come to Washington and you go to the Smithsonian, you don't have to feel guilty about dropping in for half an hour because it didn't cost you $50 to get in. That's what it costs to get into the Prado these days, just in case you're wondering. Questions? Yep.
If you had to pick one recent case that you would say is just really good law coming out of the Supreme Court, like what would you say to read?
We should restate the question for people online. So the question was, if you could choose one recent case that came out of the Supreme Court that you think is creates really good law, what would it be?
So I don't want to offer any opinions about what cases I think create really good law because I don't want to, but I'll offer you a case you should look at again. I'll offer you two different sets of cases you should look at again. Because there were some people who took a look at these cases 2 years ago and they weren't very happy with the result. I remember having a group of the Board of Governors of the ABA come in and they did a Q&A with me. And I said, there may come a time where you will look differently at these cases. Loper Bright overruled Chevron. And look at all the major questions doctrine cases from 2023. Biden versus Nebraska, that was a student loans case. Look at those cases again. If you guys took con law 2 years ago and you learned those cases and you formed a judgment about those cases, read them again and look at them again and see if you've changed your mind about how important those cases might be. I won't say whether I agree with them or not, but I'll just want to take another look at those cases and see what you think of them if you read them 2 years ago.
Thank you.
Interesting.
I told you I can deflect these cases.
Yeah, maybe we'll take one more.
Sure, I am your humble servant. As many as you let me take on.
Let's take two then. Let's take one from Professor Dolan, and then we'll take your question next, and then we'll wrap up.
On the topic of the justices engaging in this kind of diplomacy, is there ever any diplomacy with any of the tribal nations in the United States and their judiciaries?
Let me restate the question. So Professor Dolan asked, is there any diplomacy between the Supreme Court and the tribal nations?
So I'm not aware of anything in my 2 years where I have not met with any chief justices from any of the tribal nations, but that's not to say that my boss hasn't or that his colleagues have not. I just am not aware of it if there is. But we welcome all groups. And it's sort of first come, first serve, really. I mean, you know to call, we'll give you a tour. And if you want to meet with me, as long as I have a space on my schedule, I do it. I love meeting with bar groups. It's all part of the closer you look, the better we sound. And I do think if you come to our building, you'll be impressed. And it doesn't matter whether you agree with the opinions or not. I mean, that's sort of the other thing that I would always say is the rule of law is, Marbury versus Madison was a really important decision. And it's important that we play the long game here. And that it's important that the decisions, the court will ebb and flow over time. It always has. It takes a while because the election returns always follow the vacancies, so to speak. And, sometimes presidents get fortunate and sometimes not with their appointments. But over time, there's ebb and flow. And the thing that matters over that 235 years is that the decisions of the court are respected. And that wasn't always so. We have a great exhibit at the court right now on Cooper versus Aaron. So those of you who've taken constitutional law recently might remember that case. And the exhibit features 4 cases: Worcester versus Georgia. You all know that. That's the court ruled in favor of the Cherokee tribe, and President Jackson said maybe not. And then the next case is Plessy, separate but equal. The next case is Brown, overruling Plessy, and the next case is Cooper versus Aaron. So Brown, 1954, segregation is unconstitutional. The court, then Brown 2, 1955, all deliberate speed, and Cooper versus Aaron, 1957. What's going on in 1957? Orville Faubus is standing in the door of Little Rock Central High School saying, we're not letting these kids in and we're not going to obey the court's rule. President Eisenhower sends in the 101st Airborne, federalizes the Arkansas National Guard, and those kids go to school. What happened to Orville Faubus? Well, he won re-election 4 times. It was a very unpopular decision of the court. It was very unpopular in many southern states to do what President Eisenhower did. But at the end of the day, all those governors, Mississippi, Alabama, Arkansas, they all got out of the way. Because at the end of the day, they understood that the court's opinion should be respected. They didn't want to do it, but they did it. And the same poll I just read, 51% of the people now approve of the court. 83% of the people polled think it would be wrong for the president to defy a Supreme Court order. That's really important. And that's where we have to hold the line.
Final question.
What would be the biggest difference between having a majority of the justices having like a political background versus having more of a judicial background?
Question is, what would be the biggest difference between having a judiciary with judges having a political background versus having the backgrounds that our current Supreme Court has?
You know, that question would probably take a lot longer than I have to try to answer, but I think what you'd have to go back through history and maybe make your own judgment about whether you think the decisions of the 40s and 50s and 60s, which were, you know, half full of appellate judges and half full of people who had a political background versus today, and see what you think of those decisions. You know, I don't know, but I think there were a lot of very practical judges who had political backgrounds. And, you know, I think it's you'd have to really look at a lot of cases.
Okay, thank you so much.
Thank you so much. I do want to thank both of our interlocutors here. Professor Varsava, thank you for so skillfully leading us all through many decades of a fascinating career in just over an hour. And Judge Dow, thank you for sharing not only your wisdom and experience with us, but I also really appreciate, and I'm sure the students appreciate it as well, you're sharing some of your vulnerability as too, you know, those moments in your career where you felt uncertain about what you were doing and weren't really sure.
Do.
Yeah. Well, and let me tell you, that's really a strength. And I know our students, some of them maybe third-year students about to embark on their legal careers and not really feeling sure whether they're up to it. You are up to it. We've trained you well, but there are those moments of uncertainty, and working your way through those moments is what makes you a better lawyer and ultimately a better person.
Can I say one more thing about that?
Yeah, please, Judge.
Here's what this is the thing I forgot to say, which I say to all students, is people, when they're a generation ahead of you or could be potential mentors, they're actually, you think you're bothering them. They are honored to be asked. I am always honored to be asked because I would never have had any of these jobs I've had without people paving the way for me and answering my questions and giving me advice. And we are honored to be asked. Like when someone asks me for help, I'm like, oh gosh, they think I can be useful. Everybody I know who is in all the judges I know, all the bar association presidents, the only ambassador I know, all these people, they are honored if you ask them for help. And you should never feel like you're bothering somebody, because that's how you get answers to your questions. And it can never hurt to ask. The worst thing that happens is somebody says no. But almost always people are going to be honored and flattered that you thought they could help them. So don't be afraid to do that either.
Great advice. All right, well, before we close, there is a matter of important business that those of you who have been to the Fairchild lecture before know we have to go through. Every law school, I'm sure, has its own unique traditions and history and lore, but ours tops them all. This beautiful and heavy creature who has been sitting between you during this interview is the symbol of our law school, the famed gargoyle. Legend has it. When you start with legend has it, you can say anything you want after that. Legend has it, that before this building was built many decades ago, when the old law school building was being torn down, one of the gargoyles fell during the demolition process and was rescued by my predecessor as dean of the law school, George Young, who brought it back in more or less unscathed. And it has since that time served as the symbol of this law school. There was another gargoyle, however. Another gargoyle, there was one on the right and the left side of the building that was thought to have been lost, thought to have been destroyed. But no, we discovered in 2019 that one of our graduates had actually, well, he said rescued it. Some variations on this story, but it turns out it had been in this family's backyard for many, many years, first in Brookfield, then in Virginia. This part is actually true. And then coming back here to Madison, when they realized this was actually the missing twin of the gargoyle that Dean Young had recognized. So, the gargoyle judge, it represents our resilience. After all, we're tough. We're badgers here at the University of Wisconsin. No matter how far or hard you fall, you always get back up, dust yourself off, and it represents our loyalty. No matter how far away you go or how long you've been gone, even if you've been gone since you were 2 years old, you are always welcome back. And so it is my privilege to present you with the gargoyle and to tell you, you are part of our community forever now, having come to do this lecture, like it or not, and we'll welcome you back anytime.
Thank you so much.
Thanks to all of you as well for being here today. Don't worry, we'll ship that back to you so you don't have to, yeah, it is quite heavy. And I believe we have refreshments outside where you can converse with one another and if you can get through the line with the judge. Thank you so much, everyone.